Welcome back to our third session of the conference on the discursive turn in copyright. This session we're going to lead out with Professor Simon Stern from the University of Toronto. His commentator will be Mark Rose from UC Santa Barbara. Again, their very impressive biographies are available on the website or in your program. So I'll turn the time directly over to Professor Stern.
Thank you. See if I can, or should I clip the...
Well, probably right about here, if that's okay.
Super. All right. So thanks so much to Dan for inviting me, to Adelina for all of your terrific help along the way, and to all of my co-participants as well. The question mark in my title is just meant to signal that one might think that the ways that different participants in publishing and writing, their different roles might suggest that they have different perspectives on questions of copyright, and more particularly the notion of copyright as property. So just very briefly to situate in a broader context what I'm going to present, in some recent work there's been this suggestion that property was always the obvious framework in which copyright law would be understood, that it was either inevitable or from the outset just the legal framework that supplied the understanding for copyright. And my argument isn't that it's a mistake to think of it in terms of property, that it's that we took a wrong turn somewhere, simply that it wasn't inevitable, and that more particularly, if you look at different participants in the enterprise, you're likely to find different perspectives emerging along the way. So the more we look at authorial perspectives, the more of a diversity of attitudes we find, including ones that don't seem to resonate particularly with property at all. I'll just draw very briefly, this is some language from an article I published in 2012. So what I was pointing out in this piece is that although the proposal for the Statute of Anne in 1709, 1710, the proposal and the first draft of the statute were heavily laden with property-oriented language, the statute, as it was actually adopted, uses the word property exactly once and in a place that's slightly improbable if you want to take the view that the statute itself meant to embrace a property-oriented framework. So I write here that as it progressed through Parliament, the word property is gone to are the other references in the initial draft to books as property, such as the assertion that authors have an undoubted property in their books and writings, and that in the end, all that's left is a bit in Section 2 in a subordinate clause, speaking of the need to make provision whereby the property in every book may be ascertained. Just to make this a little bit more tangible, on one side then we have the language explaining how the statute was brought in originally, if you look down 6 or 7 lines, to the end that they might hold these copies as their property. And then at the very end of that paragraph, a bill for securing to them the property of books. So the initial proposal, very emphatic about property. The first draft of the bill itself, in the other column, in whom the undoubted property of such books and writings as the property of their learning and labor remains. And it goes on in that vein, the very last line, for the preservation of the property of the rightful owner thereof. All of that is eliminated. None of that language from the preamble articulating the rationale for the statute is left in the final draft. And all we have is a bit referring to the registration proposal, the registration requirement in Section 2, whereas many persons may through ignorance offend against the act unless some provision be made whereby the property in every such book to be secured may be ascertained. I simply suggest that if the statute means to adopt a property-oriented framework, that's an awfully strange way to communicate the thought, and one might instead simply think that it was left over by mistake and had meant to be excised as well. It remains true, however, that people seek out various property-based explanations for how copyright emerged or already existed in the 18th century. This is from an article that Professor Justin Hughes published in the Southern California Law Review. If you skip down to the first complete sentence, by 1743, the King's Bench Court would state without controversy that the statute of Anne protected, quote, literary property, a citation to Taunton versus Collins, which is given in the footnote as a 1746 case. It was actually decided in 1762, but whether it was decided in 1743 or 1746 or 1762 is actually of no moment. You'll see that the citation is to the English reports, not to the original version of the case as it appeared in Blackstone's reports. Just following Blackstone's death, his brother-in-law, James Clitheroe, scared up out of his literary remains many of his notes of law cases, of which Taunton was one. So if you were actually to go back and look not at the English reports, which was a reprint of many 18th and 19th century nominate law reports, reprinted in 1930, but if you were to go back and look at Blackstone's reports itself, the very sentence being quoted here doesn't appear in Blackstone's reports. You'll see that the footnote says there's a particularity in this passage in the English reports, because the statute cited here is the citation for an amendment of the Statute of Anne in 1814, which is to say it would be somewhat puzzling that judges writing in the 18th century would have known about a statute adopted either 70 or 50 years after the case was written, depending on what date you assign to the case. The answer then being no, of course they weren't aware of the statute. That was a footnote added by the reporters of the English reports. Hence, the very proposition here being articulated as one that the court could adopt without controversy wasn't adopted by the court at all. It was added much, much later. Thanks to Czar for pointing this example out to me. I actually had been unaware of it. This is from a 1998 U.S. Supreme Court decision. And the material quoted here is not from a footnote, it's from the main text of the case. By the middle of the 17th century, the common law recognized an author's right to prevent the unauthorized publication of his manuscript. C, a decision which from its very name might suggest that it probably was not a dispute about the unauthorized publications of manuscripts from, indeed, the mid-17th century, 1666. But then we get this little bit of magic. It turns out that the rationale for this mid-17th century decision was supplied just over a century later in Miller versus Taylor, and wonderfully enough, the rationale is one that will probably be visible to everybody in the room as a Lockean rationale. It's just that an author should reap the pecuniary profits of his own ingenuity and labor. The second treatise itself post-dating this 1666 decision. So again, one might doubt that this thrust to find a property-oriented common law basis, again, there's a little bit of historical magic going on here as well. And indeed, if you were to look at the case and look it up in the English reports, you'd find that it wasn't decided under the common law at all. If you skip down to the second paragraph and go down about 5 lines, we claim under letters patent, the patent granted by the king. This was entirely a dispute about what that patent authorized and whether the patent was validly granted. It was not a dispute at all about the unauthorized publication of manuscripts and whether the common law permitted that or not. So this just to say that there is a good reason for being attentive to whether we already had a property-oriented rationale at the outset or not, precisely because people seem to wish to attribute that understanding of copyright as the one that had always governed its creation and introduction. And it is right to say that if you focus on certain exponents, particularly lawyers for the bookselling industry, they had excellent reasons for wanting to ground it all in a property right. If instead we look at what writers of the 18th century had to say, there's a much wider diversity of perspectives on what copyright might be, how it might be justified, and it seems to me that there are two modes of explanation that emerge with some regularity. One that treats copyright as in some way akin to an authorial right against we might say, against self-incrimination, the right not to have others attribute words to you or make you speak words that you didn't wish to speak or that you didn't speak at all. Another, somewhat akin, another personal right, the right not to be libeled. So the right not to have works attributed to you or works or language spoken in your name that you would disavow for some reason or other. So here we find in a letter from Alexander Pope to John Gay, Pope objecting to Jonathan Swift's use of the Dublin bookseller Benjamin Mott. Pope here is confused that Mott is pressuring Swift to let Swift publish to let Mott publish his writings, and Pope says, I would be a better person to trust the distribution of his works to than so common a bookseller. Here will be nothing but the ludicrous and little things, none of the political or any things of consequence. It would be silly in him, that is Swift, to give a copyright to any which can only put the manner of publishing his writings hereafter out of his own and his friends' power into that of mercenaries. The real worry here is that Mott won't be particularly careful about Swift's reputation. He just wants to sell books. He'll just grab whatever he thinks will be appealing to the public. What Swift really needs is the sort of editor who will respect Swift's own concerns about his reputation, what he would wish to take credit for, what he would wish to disavow. And in fact, this is exactly what Swift then complains to Mott about in a letter. I've written some things that would make people angry. I sent them by unknown hands. The printer might guess, that is, guess that it was mine, but he could not accuse me. He ran the whole risk and well deserved the property if he could carry it to London and print it there, but I'm sure I could have no property at all, by which I take Swift to mean the bookseller was therefore entitled to have the profits of that edition. He's not talking about property in some absolute sense that by virtue of being the one who published it, the bookseller would then own it indefinitely, just that if you think of the risk as associated with a commercial venture, someone who was willing to take that risk was entitled to that profit. Pope much earlier, this is in a letter to William Walsh in 1706, when Pope himself is involved in an editorial enterprise. I would beg your opinion how far the liberty of borrowing may extend. And he goes on to say at the very end, a mutual commerce makes poetry flourish, but then poems like merchants should repay with something of their own what they take from others, not like pirates make prize of all that they meet. So he's addressing what I'm sure everyone will recognize as a version of the tragedy of the commons, or the possibility of the tragedy of the commons, and saying that it's one thing simply to take and reprint and contribute to in such an incompetent way or in such a minor way that you haven't improved it at all. Another thing to appropriate and improve in some way, and hence repay with something of your own. So to turn what would otherwise be a tragedy of the commons into a comedy of the commons. It is true that among 18th century writers, there were some who were quite concerned about notions of copyright as property. It's, I think, hardly surprising that Samuel Richardson was one. He was a printer by trade. He had good reasons for thinking about the enterprise as very commercially oriented from beginning to end, and to be concerned about unauthorized reprints of his books. And he regarded unauthorized continuations of his books as posing the same sort of commercial threat as unauthorized reprinting. So he says about one sequel that he hadn't approved, he didn't approve any sequels. The spurious continuation is an infringement of his right. Notice that he speaks of himself in the third person here, of his right to his own plan. He was actually continuing the work himself from materials that perhaps, but for such a notorious invasion of his plan, he should not have published. Again, when Grandison is reprinted without authorization in Dublin in 1753, where the copyright laws did not extend, he again complains, objecting to the invasion of his property. Never was work more the property of any man than this is his. The copy was never in any other hand. He borrows not from any author, the paper, the printing entirely at his own expense. So you'll notice that he treats every ideational and material aspect of the book as equivalently subject to a property regime, including the idea that he owed to nobody else any romance elements, any generic elements. He's made it all up himself, and he's therefore entitled to any sort of profit that might flow from it, and he's got a right against any use of it that he hasn't approved. On the other hand, Henry Fielding, who was equally sequeled and imitated, seemed not to worry at all about a whole series of Fielding-esque novels, some explicitly continuations of Tom Jones, some novels that claimed to be written in the manner of Fielding. The one thing he did object to was having works attributed to him that he didn't write. There are few crimes of which I should have been more ashamed than of some writings laid to my charge. Among all the scurrilities with which I've been accused, none ever raised my indignation so much as the Causedicad. This accused me not only of being a bad writer and a bad man, but with downright idiotism in flying in the face of the greatest men of my profession. So here again you see a reputational concern, and a reputational concern linked with misattribution, rather than even a reputational concern that would be associated with a sequel that he hadn't authorized. Finally, I just give you the example of the example of Samuel Johnson. So he's perhaps best known for the mot that no one but a blockhead ever wrote for money, and that's often quoted in a way that means to suggest that he was, except for money, yes, thank you, except for money. So that's often invoked in such a way as to suggest that he was a strong proponent of literary property regimes, of copyright and the need to protect authorial revenue. But here's what he has to say about abridgments in 1739. Every book, when it falls into the hands of the reader, is liable to be examined, confuted, censured, translated, abridged, any of which may destroy the credit of the author, hinder the sale of the book. And he goes on to say, so be it. Abridgments are legitimate, they're appropriate, they're desirable, and they're just one more perfectly legitimate, non-infringing way of circulating an author's work. And he elsewhere contends, in fact, that there's some effort that goes into a good abridgment, and that in some ways it may be an improvement over the original work. So all of these I just offer as ways of thinking about a diversity of perspectives on how notions of what authors would wish to protect would develop in the course of the 18th century to suggest that one might think of it as potentially eligible for classification, as I say, as a sort of personal right rather than a property right. Not to say that it's wrong to think of it in property terms, just that it wasn't inevitable that it would have developed in that way. Thank you.
And now Professor Mark Rose in response. Let's clip that wherever is convenient for you.
This is to remind me who I am. That's odd to see. Let's see if this works. Maybe it could. Does that work?
I think so.
Is that coming through okay? Yeah. Let's distinguish between concerns with property rights as such and principles of propriety. That's to say, matters related to what Simon calls elsewhere dignitary concerns. A property-oriented copyright holder, as Simon suggests in an earlier version of what he gave today, is one attentive to threats of market rivalry, and therefore one who's quick to identify and object to derivatives and other potentially competitive productions. A person concerned more with propriety might be flattered rather than threatened by imitations. In the early modern period, of course, the term propriety hovered between appropriateness or conformity to accepted standards and the more specifically economic sense of ownership, possession. This slipperiness, this lack of a clear conceptual distinction sometimes makes it difficult to determine exactly what is being invoked when early modern writers speak of propriety, as, for example, in the mid-17th century Stationers' Company insistence on booksellers' ancient right to propriety of copies. Simon's task, what he's doing here, is in part to discriminate between these two senses, the property-based concept and the dignitary concept in particular cases. As we know, the property-based view of copyright has dominated since the end of the 18th century. But this was a view, Simon argues, promulgated more by the booksellers than by authors. Authors tended to be more concerned with non-economic issues. I find this argument, the breaking apart of the interests and understandings of early modern booksellers and authors, convincing and timely. It opens up new perspectives, alternative ways of thinking to today's dominant economic and utilitarian conception of copyright. What I want to do today is to set Simon's argument in the context of the essay he actually cited at the start, his own earlier work, the University of Toronto Law Journal essay, From Author's Right to Property Right. This is an essay in which he also distinguishes between early modern authors' concerns for dignitary rights, personal rights such as attribution, presentation, and textual integrity, and the booksellers' specifically economic concerns. I then want to suggest the way Simon's continuing project, from the present presentation today through the earlier one, the way his continuing project correlates with that of Abraham Drassenauer, his colleague at the University of Toronto, and also his friend, and to ask somewhat facetiously whether we can identify here the stirrings of what might be called a Toronto school of scholarship. How did property become the default category for copyright? In the Toronto essay, Simon notes that in the early 18th century, the London booksellers, dismayed by the confusion in the book trade after the lapse of licensing, lobbied for a bill that would confirm their economic properties. The booksellers argued that they'd always treated literary properties as properties like any others, and they pressed Parliament for an act to confirm their property rights. And this became the Statute of Anne. But Simon notes that as it emerged, and this is the part of the discussion he gave us here, Simon notes that as it emerged from the legislative process, the statute did not simply confirm the booksellers' demand that copyrights be treated as possessions equivalent to houses and estates. Instead, the parliamentary process revealed a resistance to the booksellers' claims. And this appears in the excision of phrases that might suggest absolute property rights, and also in the introduction of a limited period of protection instead of a perpetual right. In considering the legislative process, Simon focuses particularly, in the earlier essay, on the introduction of the reversionary scheme. After the expiration of the first 14-year term, the sole right of printing would return to the author for a second 14-year term. This provision significantly qualified the copyright's status as property. It also provided the author with an instrument for asserting dignitary concerns when the question of renewal arose. For example, concerns as how the work might be presented in a new edition. The statute did not explicitly set out a dignitary right as distinct from a property right, but in the reversionary scheme, it did open up a space for the author's dignitary issues to be developed. Building on this point, Simon considers a series of cases that were litigated under the statute, starting with Burnett v. Chetwood, decided in 1721. Burnett, which concerned an English translation of a book originally published in Latin, is usually dismissed as an erratic decision insofar as the Lord Chancellor chose to assert his responsibility to superintend the moral content of a publication. But Simon observes that the Lord Chancellor's opinion implies consideration of authors' dignitary concerns. Lord Chancellor Macclesfield ruled that the author who was deceased might very well have objected to the strange notions that he put forward in his Latin book being translated into English and being generally available. Simon then turns to Pope v. Curl, decided in 1741, the important case in which Alexander Pope sued the bookseller Edmund Curl for publishing private letters without authority. Pope, represented by the future Lord Mansfield, might have pled harm to his reputation, but in fact he proceeded on a property-based claim. Had Pope proceeded on dignitary grounds, Simon speculates, copyright doctrine might have developed differently. Moreover, Simon suggests if Pope, the most litigious author of his time, had had occasion to sue one of his booksellers for failing to observe the author's revisionary rights, that second term, the consequence might well have been an early rejection of the bookseller's common law claim. Their assertion that copyright was an absolute property equivalent to real estate. Perhaps the landmark cases of Miller v. Taylor and Donaldson v. Beckett would never have occurred. Turning to Miller v. Taylor, decided in 1769, in which the common law claim was upheld by a divided court presided over by Lord Mansfield, Simon notes that Mansfield's decision mingled economic and dignitary concerns, using the author's non-economic interests as justifications for an assignable property right. Analyzed in this way, it becomes apparent that the potential for a more complex and nuanced understanding of copyright, one that would go beyond the purely economic, was also latent in Lord Mansfield's jurisprudence. In this way, Simon invokes the possibility of an alternate history for copyright, something like a legal man in the high castle story. Copyright flies under the flag of property, and this encourages a flattened and constrained view based on economic analysis. But as Simon shows, the potential for a regime based on personal or dignitary rights as well as property rights was present in the 18th century. Simon's taking this theme further today, noting that while the booksellers promoted the view of copyright as a form of property, few writers took the same position, and those that did, like Samuel Richardson, a printer as well as an author, were especially situated. In developing this observation, Simon returns to the key figure of Alexander Pope. He gives us a close analysis of the letter to John Gay, in which Pope discusses Jonathan Swift's dealings with the bookseller Benjamin Mott, and Simon shows that Pope's primary concerns are with dignitary rather than economic issues. Pope fears that Mott, a mere common bookseller, will not present Swift's writings in a sufficiently dignified way. Significantly, Pope's 1732 letter is one of the earliest appearances of the phrase copyright in the record. Pope was essentially a professional writer. He made a fortune from his publications, especially his translations of Homer, and he was the first author to make regular and repeated use of the Statute of Anne to promote his interests. Nonetheless, Pope always presented himself as an amateur rather than a professional. Why did I write, he asks in the epistle to Dr. Arbuthnot, answering that he produced verse not as a task or a calling, but merely as a pastime to amuse himself and his friends. As Pope's complex and fascinating engagements with the idea of literary property remind us, copyright was legislated before authorship was fully established as a reputable profession. Printing and bookselling, however, were enormously important and heavily capitalized enterprises in this period. Authors' concerns were indeed somewhat different from those of booksellers. It's not surprising, then, that Simon should find that for most of the 18th century, it was the booksellers rather than the authors who understood copyright principally in economic terms as exploitable property. By opening up this split, Simon exposes something of the historical contingency of the utilitarian concept of copyright that we've inherited. In an interesting way, I think, Simon's project connects with that of Abraham Drossenauer, his Toronto colleague. Drossenauer recently published a book called What's Wrong with Copying, in which he attempts to reconstruct the foundations of copyright theory. In place of copyright as a property right, Drossenauer proposes a view centered on the notion of authorship as speech. Whereas traditional copyright focuses on the relationship between the author and the work, Drossenauer's approach considers the relationship between multiple speakers, between members of a community engaged in conversation. The author thus becomes a speaker among members of among other speakers, rather than the originator of a commodity. The work becomes a discourse rather than a notional object. Speech implies response. All speakers are in principle equally empowered to participate in the conversation. Drossenauer's approach thus directly challenges the dominant instrumentalist conception of copyright, the notion that copyright provides the author with a limited property right as a spur to cultural production. It does so precisely by insisting on authors' dignitary concerns, authors' equal rights to enter into the discourse that constitutes society. Drossenauer's approach is theoretical and philosophical. He exposes some of the ambiguities that underlie the utilitarian approach to copyright as property. But Drossenauer also reaches back into history, and like Simon, he explores the tensions that underlie Lord Mansfield's jurisprudence. Simon finds that Mansfield was sensitive to dignitary as well as economic concerns. Likewise, Drossenauer finds that Mansfield thought of copyright in terms of an action as well as a notional object. It was, of course, Mansfield more than any single figure who helped establish the common law approach to copyright as property. In going back to him, and of course to his important client Alexander Pope, both Simon and Drossenauer are prying open the well of copyright discourse at its source. But more important, I think, is to note that their projects are complementary. Drossenauer seeks to reorient copyright theory from one that is property-centered to one that is author-centered. Likewise, Simon uses copyright history to challenge and raise questions about the dominance of a property-centered theory of copyright. This provokes my question. Can we identify here the stirrings of a Toronto school of copyright analysis? Half facetious. Thanks, Simon. That's yours.
Thank you. Don't go too far away. We will continue to remind you who you are. Simon, perhaps you'd like to respond a little bit?
Yes, so just very briefly, I'll say thank you so much for that response, Mark, and for bringing out 2 points. One, the implicit criticism, which I now realize I should have made more explicit, but I hadn't realized myself how embedded it is in this project, the criticism of a utilitarian framework which is associated with the property framework as the default conceptual structure for understanding copyright. And second, for showing how much more I turn out to agree with Abraham than I normally imagine that I do. Since on any given day I'm always thinking that he and I are diametrically opposed, and yet, as you've shown, we're surprisingly similar, converging on a surprisingly similar place. So thank you.
Okay, I see a number of hands coming up. Not surprisingly, Jessica Silby might have a thought on.
I'm not a copyright historian, so my question has to do with so perceiving the property versus proprietary or propriety distinction, and how it has evolved over time to be more property-like and thus alienable. As one of the features of the property right is that you can transfer it, which is what distinguishes the booksellers from the authors. I would have thought that maybe in the licensing practices of this time, you would see attempts to keep what you don't want to alienate, which would be your privacy or your dignity or something like that. That is, we see in the disputes, like Pope versus Curl or other cases, that the subject of the dispute is not necessarily the property interest, it is the dignitary or the privacy interest. So we can see in the disputes the other values that might underlie the author's interest. But I'm wondering if we would see those in the transactional practices as well.
Please.
You're asking, I think, about the assignments or the contracts
Yeah.
that authors would make with booksellers
Yeah.
in this period. Most of them are pretty formulaic. There's a wonderful collection of them in the British Museum, British Library. Most of them are pretty formulaic, and they're like property deeds, and they're just passing over. There are some, and Alexander Pope was involved in some, or Lord Mansfield for Alexander Pope, which are more detailed, withholding certain things, granting certain things, being rather complex in their details. Often but they don't come, so far as I'm aware, down to distinguishing quite what you would call the dignitary rights. And it's the term, that propriety term, it's wonderfully vague.
Right, it could be as much as control over marketing, for example. So if it's a question about self-libel or something like that, you could imagine that an assignment could be, you can publish this or you can reprint it,
Yeah.
but I have control over certain places it's sold or something like that, that might have more reputational interests involved. I just don't know if that's what the licenses said. I mean, you're saying that.
I can't recall Pope's contracts immediately, or another contract that would be really important, which is John Dryden's contract for his Virgil, which exists. I kind of think you might find something like that in there.
And I was wondering a bit as Simon was showing us the various quotations and snippets, how different the quotations he was showing us were from things that you hear from authors and creators today.
Yeah, no, there's a lot of similarities. Obviously, I hear a lot of
Yeah.
similarities between contemporary concerns and
Yeah.
the origins, as you're saying, of copyright.
Yeah, so just very briefly to follow up on Mark's, I think all of that's exactly right. They're highly formulaic, and every once in a while you find one. Usually, the provision that they make is if there's a second edition, that they'll have the opportunity to correct it or amplify it in some way. It's not at all common that you even see that, but that is the one provision that you sometimes see, and I believe it's right to say that Locke's contracts, some of which have survived, have some features like that. There's a wonderful article on Locke's publishing contracts that Peter Lindenbaum published in the library some years ago.
Please give us your name and where you're from.
I'm Robert Folkenflick from UCI. Thanks for these two really rich and full talks. I'd like to focus a little bit on the relation of Pope to all this. It seems to me he comes in so many different ways, including fair use. I'll get to that. For one thing, as mentioned, Mansfield, or Murray, as he was known, was Pope's lawyer. And one of the things I wanted to ask, since Pope's couplet from the Essay on Criticism is very well known, true wit is nature to advantage dressed, what oft was thought but ne'er so well expressed. Mark Rose in this room has talked about its relationship to Blackstone's on copyright, and as part of what I'm dealing with here, the question would be for Simon whether that figures into Mansfield's jurisprudence in relation to copyright. But I wanted to bring up the fair use question. I don't think it really figured for Pope much, but he unquestionably used a little-known poet called Creech He said, "Not to admire is all the art I know, to make men happy and to keep them so. True words, dear Murray, need no flowers of speech, so take it in the very words of Creech." In other words, he was saying that he was using Creech in the couplet before, but if you look at what Creech wrote and what Pope wrote, yes, Creech is in there, but Pope is taking 2 lines to give you what takes Creech 3. And so he's almost like the Olympic athlete running circles around his competition. That, to me, brings up that fair use question, but I'll leave with the question for Simon that I asked.
So thanks for those examples, which are wonderful. Whether it influenced Mansfield's jurisprudence is hard to say, because it's very hard to find good examples in the jurisprudence in which what we would now call fair use was actually in contention. The scope of copyright was so poorly defined and was generally understood really to apply merely to verbatim reprintings of texts at the time. But one of the reasons why your Creech example is so wonderful, you'll probably know that one of Pope's disputes was with the dunce, James Moore Smith. Moore Smith had asked Pope for permission to quote, so Moore Smith wanted to quote 6 lines of Pope's poetry in a play that Moore Smith was writing, The Rival Modes. Pope granted permission and then withdrew his permission. Moore Smith nevertheless did include those lines. He italicized them to show that they were quoting. Pope angrily tormented Moore Smith as a dunce in the Dunciad for precisely that episode, which he drew great attention to. And in a wonderful example of someone making fun of what you might call a literary repossession man, Fielding then lambastes Pope for being so petty about that little bit of micromanaging of the ownership of his verse. There's an episode in one of the prefatory chapters in Tom Jones where Fielding regales the reader with this episode and then says that Pope luckily found the quoted language in this play and retaliated against Moore Smith for this bit of méchanceté. So to me that suggests that Pope certainly was concerned with even what we might call fair use today, but one reason why the Creech example is therefore so wonderful is that it shows how perhaps inconsistent he was on that point, you might say, and at the same time, the Fielding example shows up again the difference between 2 proprietary mindsets.
Mark, did you have something on that?
Just as a start, I think it's impossible to exaggerate the importance of Pope and Mansfield, William Murray, in the development of copyright history, and specifically in the case of Mansfield as the turn towards the proprietary to property. Mansfield was a young man when he was Pope's lawyer. He was William Murray at that point, and Pope was very, very important and very, very famous, and Mansfield was impressed. Mansfield was impressed all his life with the fact that he had been Pope's attorney. And I've found, I can't repeat it here for reasons of memory, not because it's unrepeatable, but I've found in Mansfield's jurisprudence, in his opinions, direct echoes of things that go back to his interactions and conversations with Pope. So I really think that you can't overemphasize the significance of that relationship. It's the key relationship.
So I'm kind of fascinated by this man in the high castle alternative history question, because what Simon is telling us is that this primary concern with the dignitary interests of authors, which we would now associate with moral rights, and the utilitarian or kind of pecuniary concerns, at least I tend to think of as being sort of uniquely American or out of the United States tradition. So, where did we deviate from that? I mean, obviously, part of that still exists. Jessica Silby hears it in the interviews that she does. The law in most countries, maybe not this one, recognizes that. Certainly Canada does. Where did we take that turn?
Yeah, so thanks for pointing that out. I would say that there's at least one significant difference between how moral rights tend to be conceived and what I'm characterizing here as a personal / reputational right, and that is that in many moral rights regimes, what we would call derivative uses can be monitored or censored or forbidden by the owner of by the author of the original work, whereas it seems to me in the examples that that I've seen in these early episodes, instances of imitation, sequeling, commentary, satire, etc., all sorts of uses of the original work are permitted, and again, the only person to complain about that I've found is Richardson. So it's not to say that that attitude is absent from the 18th century, but that he certainly is an outstanding instance. And that to the extent that we see reputational concerns here, they're about having the work reprinted verbatim, but in some way that the author wouldn't want. Or works of the author printed that the author didn't want, or works attributed to the author that the author didn't want. So there's at least that little bit of difference between how moral rights tend to be conceived and this reputational notion. Now, how they came apart, I think that's a wonderful question. I think to take that seriously would actually require more work in, say, what happened between the later 18th century and probably the period in which fair use really does begin to be elaborated explicitly in Anglo-American jurisprudence around the middle of the 19th century. So I don't have a good example. I don't have a good answer to that, but I think it's a marvelous question for understanding how often in legal history what you find are that ideas that we now see as so interlocked that they're all part and parcel of each other actually take quite a while to evolve, such that all of those seemingly related pieces seem interlocked and ineluctable.
Mark, any comments on the trajectory of moral or dignitary rights?
No, I don't. I think I'll pass.
Okay. Ellen Burt from UCI.
I hesitate a little to ask this question because it's based on a half-forgotten reading, 30 years ago, in early copyright law in France, when they were just kind of going for the idea. But the claim was made in this 1819 or 1821 book, whose title I will someday find for you, that what a work was a gift to the public, and that the author nonetheless had some limited rights related to the candles burnt, the labor expended, and the time spent. And that seems to me to be a form of, because you've got a gift economy and then a property economy, if you like. Something like what you're seeing in the moral rights, but also in this sort of reputational concern, because it suggests that the author is both a gift giver and has reputation as a gift giver, which then extends kind of infinitely, long past the moment when the copyright would be at an end. Right? So, a comment really more than a question.
Yes, thanks. So, just thinking about that question in the context of British law and British discourse as it's evolving at the time, to me, one of the striking things about this sort of reputational way of conceiving of it is that far from lasting infinitely, the kinds of personal rights that English law recognizes that I see as analogies, the right against being liable, the right against self-incrimination, are rights that are so personal that they don't survive the death of the author. So, quite fascinatingly, rather than having a reputational significance that either could be passed on to the publisher or inherited generationally by the author's offspring, the thought would be that it only lasts as long as the author's life, and after that it's a complete free-for-all as to what anybody would care to do with it. So I think that's also a quite fascinating implication of it, because it speaks to duration as well as there are some aspects of scope that come in here.
That's right. I'm trying. I've read that. I know that. Quite, yeah, but I can't think. I can't think of it.
Charles somebody.
I can't think of it either. No, it doesn't come back. The idea of writing as a gift to the public comes back repeatedly, and comes back as a critique of. I'm thinking of the book about 20 years ago, The Gift.
Yeah, Lewis Hyde.
Yeah, right. Comes back as a critique of this proprietarian, utilitarian view of copyright.
Brooke Thomas, UCI.
I thank both of you. As always, your work really causes me to think and stimulates thought, and so I'm just going to share two aspects of legal history that I've looked at, which aren't really directly to copyright, that your alternative possibilities raise. And my only question is, tell me if I should just forget it and I'm speculating too much, or if there's something to pursue. So one has to do with, and I know Mark knows this case very well, is of course the Brandeis and Warren's right to privacy, 1890. And of course, it makes the argument for, so there's no tort right to privacy in common law. They say there is one, and it's implied in copyright. Why in copyright? Because you have a right not to publish. And so this then leads to then this right to privacy. And they try to separate it from property as a property right. At the very same time in the nation, Godkin is writing something which is linked to it, which is called one's right to reputation. And he actually sees the right to privacy as the right to one's reputation. And this would seem to me that actually Warren and Brandeis were actually going back to copyright and then seeing something that was, from your history, was actually there from the start. So they weren't fabricating as much as we tend to think. So that's one. And the other, this is far more speculative, but it goes back to Mansfield. The idea of Pope having both this sense of the dignitary and the property, and how important the dignitary was then in Mansfield's understanding copyright. The famous slavery case of Somerset. You've got property, but you also have a sense of human dignity. And it seems to me that perhaps that would be an offbeat way of actually going back and looking at Mansfield's understanding of what was going on in those. So anyway, if you have any, just tell me if I'm being far too academically speculative or something there.
No, I think those are both wonderful observations. So I think what you say about Warren and Brandeis is exactly right. And indeed, one of the fascinating aspects of that essay is that they are so emphatic that if you just think about it in property terms, you've misunderstood what they're trying to get at. It's a spiritual right. They sort of go on in terms of various intangible concerns that sound almost religious in some ways. And so I think it's right to say that their effort to find in Miller versus Taylor in particular, this ancillary concern that's to do with natural rights, that's to do with self-ownership and the reputational right, all of that seems to me exactly right. I think you're also quite right about Somerset. So Somerset is decided 2 years before Donaldson versus Beckett, 1772. And to me, an intriguing feature of Somerset and Donaldson, so the argument on the part of the bookselling industry when Donaldson was being litigated was, if you end up quashing what we believe to be this common law property, right? Thousands and thousands of pounds of valuable property will go up in smoke by judicial fiat. And that is exactly what happened in Donaldson. And guess what? The book-selling industry survived, and in fact, in some ways, well, at least in some ways, did better as a result. That was, of course, among the many arguments against the decision in Somerset as well. People have paid money for this, and you're not going to tell them that it was all in vain. Obviously, that was also a successful argument for a long time in the U.S., for many, many decades afterwards as well. So, to me, one of the intriguing features of those two cases is that they're, I believe, the two most salient instances in which some well-entrenched notion of property was abolished by judicial fiat against the claims of the property owners who were worried about what would happen as a result.
Just to add to that footnote, of course, the earth didn't collapse with the decision. That's quite right. But the book-selling industry was transformed by the decision. So that it was transformed insofar as suddenly a massive reprint industry came up in the book-selling world, and a new interest on the part of booksellers in new books to balance the old books. And I mean, you can find in some of it the great efflorescence of the novel in the 19th century being in part a result of the change in the book-selling industry. So it really did have major consequences.
So just two quick observations on that. One is that that point's been very interestingly elaborated by a number of literary historians and copyright historians. There's a wonderful new book that Trevor Ross is publishing related to this. It'll be coming out in about a year and a half from Hopkins. He's published a bit of it in ELH maybe 2 or 3 years ago. It's very much worth reading. Second, and this is again just to speak of how thoroughly the book-selling industry was transformed. When the 1814 statute was being debated and a term extension was in contemplation, the very thing that the booksellers had been obsessed with, the reason why they wanted this common law right was so that they could insist that copyright lasted in perpetuity. So Donaldson says that it lasts 28 years and no longer. So a term extension was in contemplation at various legislative intervals in the 19th century, but particularly with respect to the 1814 statute. The booksellers' reaction was, why are you offering us this term extension? It's worthless to us. There are many other things we'd much rather have. They got much more interested in scope and potential conceptions of derivative use. But the idea that a term extension, any term extension, 14 years, they regarded as such a useless addition to what they had that they were just completely contemptuous of the idea that it might serve any value at that point. An amazing turnaround.
So there are several more questions, but we are at the end of our session. Let's thank the panel.
Thank you.
And we're going into our lunch break. For those of you who are physically here, lunch should be available again just outside the room. You've got about 45 minutes or so to get something. There should be some tables reserved for you outside. Probably not enough, but at least a chance to stretch your legs. Please be back here at 1 p.m. In your seats, at which time Professor Tony Reese from UCI will introduce our keynote speaker, Barton Beebe. For those of you who are following along on the web, we'll see you back here at 1 p.m.